Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. We are again doing a follow-up on the matter of Billy Broussard versus Mindy Gerard, aka Mob Boss, and also Melissa Dubrock. Everyone may recall from our last feature on this that there was an expedited hearing that was set for April the 3rd. That was after a filing. What we're talking about is a filing for motions for sanctions under Code of Civil Procedure 863. Which is extremely rare and almost unheard of. And the bar for clearing that is incredibly high. But nevertheless, that's where we are. Now, there was an expedited hearing for April the 3rd after the actual request for the hearing was made by Defense Attorney Haik on March 30th with a support memorandum supplied the next day, March 31st. So you're talking about 2 days, and that includes a weekend. For Mr. Broussard to get geared up for this, quote, expedited hearing, unquote. You opted not to attend. Would you like to elaborate as to why you opted not to attend that meeting?
Well,
I mean that hearing, I'm sorry.
The fact of the matter is the case was dismissed. Clerk court paid their costs, court costs, and clerk court made it clear that there's no reason to come to court. And I assumed that the judge's office would have gotten that, and as soon as she would have gotten that information, you'd have seen, just like the clerk court told me, it's scratched out and it's dismissed.
It's dismissed. The case is closed. The case is closed, and furthermore, they had that docket because it's the clerk's office that gives the docket.
Right.
Item number 5 on that docket. We have a copy too. We previously supplied it, but we don't see the need to do that again because it was so clear that. So it begs the question of why the court may have proceeded with a matter deemed to be dismissed and closed. But be that as it may, you did not show up. And so what happened is they rescheduled the hearing for May the 23rd. And today Mr. Broussard filed his opposition memorandum, and that needs to be done at least 8 days prior to the hearing. He filed it a few days early just to be on the safe side. But it also begs the question, how was he supposed to file an opposition memorandum for the April 3rd hearing when the motion for expedited hearing itself was not filed until March 30th? The bottom line is I can only surmise that neither the judge nor defense attorney Haik wanted you filing an opposition memorandum. But they'd have to speak for themselves on why they went the route that they did. So in looking through your opposition memorandum for the motion for sanctions, and again, we're talking about 863 sanctions here. So I know we have a number of attorneys who will be very curious as to how this turns out because the bar for being awarded 863 sanctions is incredibly high. It has to demonstrate that your suit has zero merit, that was filed in bad faith, and I think as you look through a lot of the exhibits that have already been filed in your case and the ones that were added to in the present filing, anybody ought to be able to surmise this was far from frivolous. But at any rate, in looking through, I noticed in there that you basically said that defense attorney Haik, if he wanted to recover attorney's fees, which clearly he does, that's the only thing that's left. There's nobody's in dispute on anything else. You've agreed to dismiss it with prejudice, which means you can't bring it back. You've paid the court costs. A check was issued. We don't know if they deposited it or not. When I say they, I mean in Haik. So even Judge Bourne at that April 3rd hearing, he said, look, the only thing that's unresolved here is the attorney's fees. I also found it interesting, we're providing a transcript of that hearing, that he said that if I am inclined to award any, it will only be after a proper hearing where you have been served, which you now have. And you will be there on May the 23rd, obviously, because this time the court chose to do things the right way, for lack of a better phrase. And so, at any rate, if Mr. Haik, you were stressing that if Mr. Haik wanted to procure these attorney's fees, which clearly he does, the proper procedure to have done that would have been to file a motion under Louisiana Code of Civil Procedure 971. And I know we've mentioned 971 numerous times. I want to commend you on your extensive use of sound-off features to include the judgment against Murphy Painter, where 971 was successfully asserted, and also the judgment against Calvin Braxton. Now, Calvin's judgment was for a little over $50,000 in attorney's fees. Both Mr. Painter and Mr. Braxton are appealing them, but I think I'm sure that was your motivation, is to say, look, this is how you do it the right way, by attorneys who defend against defamation suits. Am I correct on that?
And I was aware of it. I was aware of 971.
I know you were.
Waiting for the days to pass. I mean, I was waiting for that 90 days to see if he was going to come with that. But
well, yes, and the reason he's familiar with it, you're probably watching one of the most dedicated followers of the Sound Off blog out there, period. In fact, it's his nephew that painted the very logo that I now try to use as much as possible, especially when we're in this facility. So to commend you, you follow this blog religiously.
It's about the closest thing you can get to cameras in the courtroom.
Well, and trust me, I'm pushing for cameras in the courtroom. I know you know that. So let me commend you on that and your ability to have those exhibits to say, look, this is what you should have done. And I notice you make some subtle references in there that perhaps Mr. Haik may not be that extensive of experience in filing or defending defamation suits, whereas Ben Mayu, who was the attorney that was serving as the defense attorney with regard to Calvin Braxton, he's with Nooner and Pate right there in Lafayette, and also Amy Groves Lowe, who is an attorney with Taylor Porter, and she was the attorney in the Murphy Painter. Well, at least she was the one at the point where the sanctions were awarded. And I noticed you even said perhaps you may want to deploy their services, meaning if you ever sued for defamation again. And you even gave their contact information, email addresses and phone numbers. They may even appreciate the free plug, Billy. So, if you want to elaborate on providing that resource, go ahead.
And if attorneys don't practice that law often, if nothing else, reach out to them maybe as co-counsel. I mean,
there you go. Just tap the shoulder of somebody who may have a little more experience, because as you well know, the moment this was filed, our viewers have to remember, as I stated in the last feature, I had 971 filed against me twice. Both times in 2011. It's now been 12 years. Now, just because you file it does not guarantee it's going to be awarded. In my case, neither one of them were awarded. Now, much to the chagrin of Mr. Painter and Mr. Braxton, they both were awarded attorney's fees. But if Mr. Haik was going to do this properly, especially wanting to assert a First Amendment right, well, that's exactly what 971 was meant to cover.
And I didn't think they would get across that hurdle anyway. It's just the idea I wanted to see. Are they going to?
Well, and part of the reason you wanted to see, I'm going to be blunt, for those our listeners, I said, Billy, I don't call him Mr. Bruce. So he calls me Mr. Burns all the time, but I call him Billy. So I said, Billy, there is no way that he's not going to file 971. It's not going to happen. And as the days went by and the days went by and the days went by, I said, he's running out of time, and well, lo and behold, he didn't file it. So, all right, so I want to also emphasize that you recently filed a voluntary motion to dismiss in another matter, Billy Broussard versus Scott Lopez and his son Benjamin Lopez. And we give you the transcript where Mr. Haik says these cases are, his words, not mine, identical, okay? And the orders for the dismissal are worded the same, with prejudice, at plaintiff's cost. That matter already has been dismissed. It's been signed, has it not? And I believe it was signed by a very interesting judge, because Judge Pittman is the judge for that case, but in 16th JDC they'll let a duty judge sign it when the conditions are appropriate. Clearly, the duty judge for that day felt like the conditions were appropriate. Who was that judge again?
Actually, it was Judge Bourne.
Vincent Bourne, yes, and it's got him. We'll give that as an exhibit. So yes, he saw fit to sign that one, which would then beg the question. I wonder why you haven't signed the one that applied for your own court. So that's really hitting the 36,000 feet level of where we are and where we're going. And that hearing will be on May the 23rd. You did provide some other exhibits in there. Not that you haven't already supplied a ton. They're all Facebook posts. Not that you hadn't already supplied enough that likely would have defeated 863 sanctions. But you did file a few others, and we're not going to go over every. Well, we'll briefly at least touch on a couple of them. One of them is the one where Mindy, mob boss Gerard, got very angry with her Facebook members and said, "Now look here, this group is private for a reason. Do you know that it's illegal to take screenshots of posts and then to send them out? And so whoever this culprit is, you better step up right now, because I'm going to get to the bottom of who did this." Well, as you point out in there, all thanks to a good Samaritan, when she posted that, she had a plummet in her membership, dropped from 101 members the day she posted that to 68 members. She lost a third of her membership overnight. And interestingly enough, you point out that post was deleted.
Yeah, and it's interesting. So you put things out there and think just because you press delete that is just
no. That's a neat little trick. Let me delete the post. Well, you may or may not be able to succeed in its deletion. So we put that post out there.
She might have hurried up and said, "Let me delete." I mean, they will drop in like flies.
They would drop it. Yeah, exactly. If I don't delete this fast, I may not have a member left.
Right.
You know.
So I mean, probably it was the other 2/3 of the people might have not had a chance to see the post yet. So she probably said, "Let me hurry up and erase this before."
Exactly. Before I don't have any members left. I think we can take from that people don't like being threatened.
No.
Okay. And yet that's
pushed around.
Yeah, and yet that's what happened. And so she lost a third of her membership. You also point out in there that after your litigation was filed, all of a sudden there's no more post about your property or you.
And I appreciate that.
Well, of course we do, but it begs the question: why did you suddenly change your behavior if there was nothing wrong with your post?
Because I want to say this: what's bad is the neighbors, the things that the neighbors were being told through this Facebook deal was false information.
Of course,
people were even saying, "Well, why is he even on his property?" Like
exactly, they were saying that doesn't he? What happened to the order banning him from even going onto his property? Well, the reality is there was no such order.
So all this information and misleading information that was these people they're thinking this guy he's breaking all the laws.
Why hadn't he been arrested? Yeah. And we already know that Mindy mob boss Gerard did call the sheriff out, fully expecting you to be arrested for simply going on your own property. We're not going to replay that video because everybody has probably seen it by now. But the sheriff deputy had to say, "Now look, I don't know how this is going to work, talking about somebody being arrested for trespassing when they own the property." And look, folks, that's how laughable some of this stuff is.
I mean, that's what some of these people have tried. Or they thought that they could get the government to put the weight of the government on me to accomplish these things when they were still to this day. I've done nothing wrong, nothing illegal.
Well, and your point is well taken. How did these people obtain the belief that was the case? They obtained it through the Facebook group for which Mindy Gerard proudly claims ownership. Oh, and by the way, we also uncovered that everybody knows she went out and got a vanity T-shirt that had Mob Boss on the sleeves. Well, come to find out that on April 17th of 2022, she greeted everyone with a happy Easter from, and you'll see the vanity coffee mug that also had Mob Boss emboldened onto it. Also, there was a post by Melissa Dubrock, I mean, just absolutely obliterating Chris DeQueer, saying, now he is the neighbor right across the street from the property, and a top-notch guy, very intelligent guy, an engineer, and yet she said he is a snake and said he is not on our side. And that reminds me too, there was also a post where she dumped a bunch of members. Now why did she dump these members? Because they were lurking. And she reveals it. She says, look, I'm getting rid of anybody who just lurks. Well, let me just say this. If we're talking about a benign Facebook group that just disseminates out useful information, hey, there's a water boil advisory, who cares that the person is lurking? Why should that be a cardinal sin? And yet she saw fit, hey, if they're not contributing, what you can read into that, folks, is that I can't take the risk that a lurker is here just gathering information on behalf of Mr. Broussard. Well, I hate to disappoint you, Miss My Boss, but somebody was, okay? And I'm not necessarily meaning singular, somebody, all right? But
and they did it for safety. It was being done for safety purposes.
Well, that's it. But I mean, but the point is, there should be no problem with lurkers. Okay?
Right, exactly.
And here we have Mr. Haik at the outset opposing a motion to compel.
I mean, I own 33 acres.
33
in the area.
acres.
I mean, I'm not on Facebook, but just to say if I would, they should invite me to be part of the, you know what I'm saying?
Well, there you go.
But, I mean,
Yeah, well, exactly. You're an integral part. Probably had
Right.
more tied up per acre
and
than
more
anybody in
frontage on
there.
Ushant Road, I think, than anybody else
Eh,
on that in that area. So it's like I don't understand. I don't know anybody that owns more acres than me in that area. I'm a very kind guy. I don't know what's the big deal.
All right, and so we're going to kind of wrap this up because on the last feature pertaining to this, I had said that your position was very clear, even though Mr. Haik distorted it in his testimony, not testimony, but in his arguments that he posed on April the 3rd when he said that you were making a, quote, mockery of the court by stating that even if attorney's fees and court costs were assessed against you, you were not going to pay them. Anybody's welcome to go back and look at the video. Number one, you've already paid the court costs, and you had paid them at the time he said that. Okay, so number two, that's not what you said. You said that, hey, if I am assessed with attorney's fees on this, I will be appealing it. That's your right. That's not making a mockery of the court. And you have said very emphatically in this opposition memorandum, if attorney's fees are awarded, I'm going to follow the next two steps I will be taking. Naturally, you can go and look at the Calvin Braxton filings for guidance. The next two steps that will be taken is, hey, I'm going to file a notice of appeal, a devolutive appeal, and then after that, I'm going to ask Judge Bourne to issue his written reasons for ruling, because you cannot appeal something without a judge having issued the written reasons for ruling. I'm going to let everybody know. I would be very curious to see what Judge Bourne puts in those written reasons for ruling.
I don't think it's going to go that far, personally. And I will say this too: in the the opposition memorandum, etc., going through this, you have to be respectful to everyone.
Of course.
The judge, but you cannot be timid to where you're scared and
That's not what. Yeah, you're exactly right. Courtrooms.
When you're in the courtroom. Even Haik, I mean, he has a way about it. It's like he's trying to pick a fight with you, but you got to understand, we're in a courtroom. That's what he gets paid to do, but he's trying to get you to snap, trying to get you to, blow a fuse, but you have to be very respectful to the opposing attorney, the counsel, the judge, everyone involved. But at the same time, you can't be timid, you can't be scared, because they'll steamroll you so quick, and they'll turn around and laugh as they're walking out of the room.
I'm glad you brought that up, because I kind of think that was the mode that Eric Haik was in on February the 15th, which is the day that he thought he had literally steamrolled over you, and in my opinion made a very serious mistake in engaging in a darn near an hour-long conversation, he and co-counsel Ali LeBlanc. And as you point out in the opposition memorandum, it was Ms. LeBlanc who said, Mr. Broussard, please consider who our clients are. And I believe that's right, in the opposition memorandum, I think you clearly said that you did. You recognize the fact that Ms. Gerard lives in a house trailer that is on her parents' property, and therefore collecting on a judgment may be difficult. And you put in there a whole plethora of stuff. I say stuff, that's a bad word. You put in a whole plethora of filings in 16 JDC that are not very flattering of Melissa Dubrock and her husband Blake. We're going to take what you placed and we're going to have it in table format, because we have previously already presented that. So I assume we made it a little easier for you to gather that information.
When you get into it with bullies, sometimes you have to have some transparency.
No, that transparency is never a bad thing.
And I love the idea the sheriff has those body cams.
Yes, indeed.
You know what I'm saying? So that whole just call the cops and make a big scene and try to get the government to go after somebody. Those cameras, I mean,
they don't lie, do they?
Our sheriff is doing a great job with those cameras, man.
They don't lie.
That ends a lot of the problems.
So with that, folks, we pretty well brought you. Oh, and my point of all that is, when he made the assessment, just like Ms. LeBlanc had advised, he said, you know what, she's right. The best thing to do, I've gotten as much as I can get out of this. And look, let me just say this. He would not have those Facebook posts were it not for this lawsuit, because somebody saw well, I don't know if you want to go into the specifics. You know, there was an encounter, and he said, this is just wrong. It's just wrong.
Yeah.
And I can.
Many people, but just to say.
Yeah, I know. He
But
served
if it
as
wasn't for
the.
this, I would have never been able to expose the plot.
Correct.
They had against, and I couldn't understand. I was like, "What is the deal? Why are people looking at me this way? Why is this going on? That going on?" The feedback I was getting, I was like, "What is going on?" He said, "Oh, they got this Facebook."
Oh yeah, and he said this is just not right, and he said I'm going to get you everything, and I want to commend the gentleman because Mr. Haik was fighting you on a motion to compel. It turns out the motion to compel it is irrelevant now. You've got it all. I'm sure to Miss my boss's chagrin, but you have it.
Yeah,
so
even things she thought she might have deleted.
even the item she thought she might have deleted, which was the blatant threat to her fellow members. So folks, thank you so much for your dedication. The filing has been made. You're welcome to read it all. It's quite interesting. We've tried to give you the highlights, so if you don't want to read any of it, you really don't have to. But we will certainly.
I would like to say one other thing in regards to St. Martin Parish. You want to live there, do business there, do anything in St. Martin Parish, buy a property, have a little farm, develop. You cannot just tuck your tail and run every time you run into some bully that's going to try to push you around, and try to fabricate some story on you. And so stick it in there, because St. Martin Parish needs people to come into the community, and or the people that are in the community to develop land, do different things. So anytime you hear that word, these people that want to act like a Karen, I think is the people call it.
I had never heard of that until you. Of course, you have 5 young girls,
well,
so no one.
From them, just from the young people world, they say
having a Karen. That's what does that mean?
Yeah, exactly. I didn't know what they were talking about. But just to say, never just tuck your tail and run and be scared of that type.
Well, let me tell you something. I believe if people have learned nothing else about you, it's that tucking your tail and running. I don't believe is in your DNA.
I'll turn around and run right at them. Respectfully, don't want to hurt nobody, but at the same time, you've got to expose it. I mean, and at the same time, most of my friends I have in life are people that I may have met, and just to say we locked horns at the beginning, and they're my best friends now. So you never know what the future may hold.
That sounds great. Well, thank everybody for tuning in. We will report to you, good, bad, or ugly, whatever the results are of the May 23rd hearing, assuming it does in fact transpire, because that's all in the hands of Mr. Haik and his clients. But if it does proceed forward, we will most certainly let everyone, including what I'm sure are bound to be a number of attorneys, know the outcome. Thank you once again for tuning in, and we look forward to bringing you that follow-up feature sometime shortly after May the 23rd. Thank you once again.